Now, we specifically look at the origins of trademark law. Let's look at the early days discussion about trademark as such. The ancient Greeks largely kind of used certain kinds of symbols and marks on their artifacts and potteries, largely to kind of indicate that it came from a particular source, from a particular king as such. The Egyptians subsequently used symbols on their structures. The Romans went one step ahead and started using symbols on certain products like bricks. So largely you would find symbols and marks on swords, potteries, etc. For instance, the sword manufacturers in England were specifically required to use symbols to identify the makers. If there was a defective sword, it could actually be traced back to the maker. Later on, marks actually came to be associated with merchandise makers as trade increased, right? Then the trademark system actually kind of takes a turn in the Middle Ages when the guild system started. With the emergence of the guild system in the 14th and 15th century, the guilds were always concerned about the risk of counterfeits and the impact it has on their reputation. So they insisted on all the members of the guilds to kind of use marks, and these marks would act as source identifiers. That is basically who actually within the guild made these particular products. All the members of the guild would require to identify themselves, right? So if they baked a bread, they would impose a mark that will indicate the guild, that will indicate the street, that will also indicate who actually within the guild made it, right? This enabled the guild members to actually trace back a particular product if it is defective and punish the person for not maintaining the quality. Now, the guilds and marks, right, were largely kind of practiced widely among the London bakers, right? It was very popular among the London bakers. They would generally use these marks on whatever they baked. Largely, guild marks protected the goodwill of the guild, but not necessarily that of the individual trader. So you could basically look at the early marks as some kind of a mark to represent the quality of a particular guild. There were harsh punishments imposed on people who were involved in counterfeiting, and there was very important cases that actually emerged during that time. One of the important cases was that of Southern versus Howe, where a cloth merchant who had been using a particular kind of mark on his cloth brought a suit before the court saying that another person was actually kind of used his mark on cloths which were actually of inferior quality, and as a result of it, it kind of created deception in the minds of the consumers. So this was probably, you could say, one of the earliest cases related to trademark infringement and passing off. Subsequently, you had a very important case called as the Sandford's case. Here the plaintiff sold clothes with the mark JD and had developed a reputation for quality clothes. They used these marks on handkerchiefs, woolen cloths, etc. And for a number of years, they had gained reputation for quality. Now, the mark JD meant or represented a certain quality, right? Customers and traders would actually buy clothing with these marks and would specifically ask for these marks, clothes with these kinds of marks. Now, this basically meant that they largely relied on the mark JD, which kind of represented a certain kind of quality, which kind of told them that it originated from a particular place or particular manufacturer. Unfortunately for the plaintiff, the defendants deceitfully used the same mark JD on the clothes, but the quality of these clothes were much below, and they used it for a period of 2 years, which actually resulted in the slump in sales for the plaintiffs. Basically, the plaintiffs could no longer sell as much volume of their clothes because customers actually thought the plaintiffs were started to make low quality clothing as such, right? As a result of the defendants' low quality, it kind of became really difficult for the plaintiff to sell their products in the market. So they actually brought a case before the courts wherein they claimed that the defendants were actually trespassing. Now, the court allowed the plaintiff to recover the damages for interfering with the plaintiff's property. So this was probably an instance where the court recognized that for the limited purposes of trade, there was an instance of recognizing these marks as property, right? Subsequently, you had what is known as Blanchard versus Hill. Plaintiff claimed he had exclusive right to use a particular kind of mark called the Mughal marks on playing cards. The exclusive rights emanated from the charter granted to card makers. Now, the court failed to recognize the rights coming through the charters, as it believed the intention behind the issuing of charter itself was illegal. Then you had another case which is well known for trademark law, which is known as Sykes versus Sykes. This was an English case where the courts had the opportunity to decide the right to use a mark in 1824. Plaintiff basically complained that the defendant used their mark Sykes on his product, which resulted in the drop in sales. The court agreed that the defendant was relying on the reputation of the plaintiff to sell his goods. Subsequent cases were brought on the basis of deceit, that is, defendant defrauded the plaintiff. So, in a number of instances, trademark was recognized as a property, and in the initial days, you could bring in an action of trespass or an action of deceit. But later on, once the court started recognizing trademark itself as a property, origins of all the litigation would entirely be based on the fact that trademark is a well-protected property, right? Subsequent developments were also found wherein it was immaterial whether the defendants knew about the mark's existence or not. That is, if a mark had gained reputation and the defendant used that mark, regardless of the fact whether he knew that it existed or not, would be immaterial. This was covered in Millington versus Fox. Subsequently, courts also recognized actions on the basis that there is property rights in the marks and not merely on the basis of deceit. This was actually recognized in leather cloth versus American leather cloth.